Start the program.
Shipriya,
Yes.
good evening.
Good evening, sir.
This is the link for me, no?
Yes, sir. Yes, sir.
Right. Okay. So there will be screen share option and all available?
Yes, sir. Yes, sir. Screen share
Okay.
is up.
Fine.
So a warm welcome and a very good evening to all joined here today for the program with the subject Recovery from Personal Guarantors, a legal perspective and view of provision of SARFAESI and IBC. On behalf of NCLT Kochi Bar Association, would like to invite our President, Advocate Philip Matthew, sir, to deliver the welcome address. Sir, off to you, sir.
Good evening to all. Today, we have gathered here for the professional development program, and we decided to start a professional development program like this as the first after the formation of the NCLT Bar Association, and we have got 61 registrations. So now my job is to welcome the participants and our chief guest to this special function. And before that, also I would like to make a passing remark about the subject which you have chosen. There is a recovery of personal guarantees, recovery from personal guarantors, a legal perspective in view of Insolvency and Bankruptcy Code and SARFAESI Act. And it's very relevant for the practitioners of, especially bankruptcy practitioners coming from legal profession, secretarial profession, and chartered accountancy profession and cost accountancy profession. These are the professionals practicing before NCLT and NCLAT. And with regard to SARFAESI Act, there are forums like DRT, High Court, etc. But here our attention will be the legal perspective and the legal issues involved in recovery from the personal guarantors. And we are trying to find out a good speaker for this. And the first name that came to our mind was Dr. K.S. Ravichandran. And Dr. K.S. Ravichandran is a practicing company secretary, and his qualification shows that the education that he has acquired along with the experience in different fields. He started his career as in the Indian Air Force, and he was a specialist in Russian radar systems. And from there, he focused, and in his radar, the company secretarial practice was caught, and he changed his profession from the technology as a technologist or a specialist in the radar systems to a corporate specialist. And in Coimbatore, I inquired, and I found that there is nobody to beat Mr. K.S. Ravichandran in Coimbatore or in that industrial belt, so far as his practice is concerned. I have seen many company secretaries changing their profession from secretarial to legal profession. And even our secretary of the association recently became an advocate from the secretarial profession which he was pursuing. And I inquired, and I found that why Mr. Ravichandran is not changing to legal profession, even though he's a very good arguing counsel, because he faces no competition in the practice, in the secretarial practice, which he has got and which he has developed. And it's a self-made, he's a self-made man, to my knowledge, and he is a doctorate in in a subject which is close to company law. That is, even though he has taken from Department of Management of Alagappa University, his special subject was prosecution of directors under company law and criminal law, which is a legal subject. And he has authored several books, that secretarial securities and management audit, limited liability partnership laws, related party transactions under Companies Act, corporate social responsibility, and he has authored and a treatise on offenses under company laws. And he was one of the special editors of the Guide to Companies Act by Ramayya, and he has authored as many as 1,000 articles on corporate laws. I was wondering how he got so much time in his busy schedule as a practicing company secretary. We have to admire his hard work and dedication to the profession, and that is why he has earned a name as a corporate specialist and expert on many parts of this country. And he's an independent director of Karur Vaishya Bank Limited, presently a member of the Banking and Finance Corporate Affairs Expert Committee of Bangalore Chamber of Industry and Commerce. Insolvency, and he's presiding the chair on Insolvency and Bankruptcy Court Committee of ASSOCHAM's State Development Council. All these positions are a clear proof of his capacity, ability, and the skill in the particular subject which we are going to hear today. And when I speak of this subject which we are going to hear from him, we can see that even today there are resolution process plan, and in the when there is a resolution process, if there is a resolution plan is accepted by the committee of creditors, the creditors have to go for a lot of haircut. And with the notification of section 95, because section 95 came under part 3 and part 3 provisions were notified. This was notified in November 2019. Even though it was challenged, that notification, so far as the corporate guarantors are concerned, it was unsuccessful before the Supreme Court in, as you all know, Lalit Kumar Jain versus Union of India. So, and with regard to the SARFAESI Act, he will be dealing with the recovery as against the personal guarantors under the SARFAESI Act. As you know, the liability is coextensive under section 128 of the Contract Act. So all these aspects will get a detailed analysis, I hope, and we will go wiser after the this seminar. And I hope, and we are all looking forward to hear a very enlightened speech from no less a person than Dr. K.S. Ravichandran. And I welcome him with and also I welcome on behalf of the office bearers of the NCLT Kochi Bar Association to this function. Second, we have got our Secretary Bijoy Pulipara, who has been instrumental in making this event a reality, along with Supriya, and our patron, Mr. Jinan, who was a judicial member of Calcutta NCLT Bar Association, and all other professionals who has registered for this function. And I welcome all of them together and individually to this function. So I conclude my welcome speech by wishing that this first event of our association be a grand success. Thank you.
Thank you, sir. Thank you, President, for your wonderful welcome address. And would like to invite Dr. K. sir to take up the session. Thank you. The stage is yours.
Good evening to everyone. Thank you, Sri Priya and Vijay Pulipura. Philip Matthew sir is known to me for decades. Such a nice, very simple and humble, very senior professional in the field of corporate law. I still very vividly remember certain matters before the Cochin High Court in terms of very, very unique, schemes of arrangement. Sri Philip Matthew has only represented the cases for us in High Court. Very difficult, very difficult schemes of arrangement were constructed. And I'm very happy that we are able to see to now each other and listening to his words. So nice of you, Sri Philip Matthew ji.
Thank you.
Very thankful to you. Personally, I feel such a beautiful, affectionate person has spoken in the introduction. And by himself, though he says I am an expert and all, he is a very erudite expert personality here. And I'm thankful to this the organizers, NCLT Kochi Bar Association, for this wonderful opportunity, which has given me a lot of, I can say, time for preparation and all. In fact, in 2000, I think in 2005, the first edition of my book on, the treatise on corporate law. I don't know how it is visible.
It's visible.
Treatise on corporate lending charges, debt recovery, and the winding up of SARFAESI Act and DRT Act, and winding up. All these things were published by All India Reporter in 2006 itself, the first edition. Because the field of debt recovery law, the field of offenses and prosecution, like for example, contravention, compounding, adjudication, prosecution, the defaults, delays, the deficiencies and all, these are all forever, they are going to be there. There may be slight changes in the procedures. There may be some provisional changes. There may be some substantial changes. There may be some changes like from civil court to DRT to SARFAESI to IBC. The journey will go on, but the issue of dispute relating to all these things will continue, because that is a perennial, permanent subject at all times. Howsoever you may be adding clarity in the contractual clauses. So that is the kind of situation we are seeing. We are all aware 2016 December, when the IBC was introduced, there was no provision called personal guarantors to corporate debtors. That was subsequently introduced through the notification in 2019. To be precise, the notification was issued on 15th November 2019, 4126E. Prior to that, we need to have slight understanding, which I am sure that everyone would have already gone through this thing. We had originally the civil court for recovery, and years together it will take. Whereas, parallelly, we also had, in respect of corporate borrowers, the Companies Act provided a 500 rupee threshold. And a debtor is liable to face the music before the high courts in winding up petitions. Those days, there are cases where we used to present petitions for the winding up of companies under the 433 read with 434. 434 is important because it gives a deeming clause that a company is deemed to be unable to pay its debts if a sum of rupees 500 the company is unable to pay even after the notice. And notice can be given by the authorized agent or the company to the debtor, and 500 rupees all that the amount mentioned in 434 to bring the legal fiction, deeming fiction that the company is unable to pay its debts. And the moment the company is unable to pay its debts after this notice, has served on the company a demand in his hand requiring the company to pay the sum. That's all. So if the notice is issued and the 500 rupees, all that the amount mentioned there, if it is not paid, the company neglects it, disregards it. 433 applies, and a creditor has the right to move the High Court, filing a petition under 433 read with 434, which says a company may be wound up by the High Court, that is the court, if the company is unable to pay its debts. You please see the 1956 Act in the several years before. Today, 2016, we are now seeing 60 years after, the philosophy has not changed. The same deeming fiction is what is being used. 1 lakh is the criteria, if you remember, when the IBC was introduced. In company law also, by an amendment, second amendment of 2002, the 500 rupee threshold was increased to 1 lakh, 2002. But it was not notified. Thereafter, we had only the company law committee and so many amendments. Ultimately, it saw the light of the day for the first time in Companies Act 2013. Some of the provisions were introduced on the 12th September 2013. The point is, winding up was a useful weapon in the hands of creditors, provided at least 500 rupees is the sum due and the company, the borrower, the debtor neglects to pay. Same thing is now also used, despite several years, in the Indian landscape. The scenario has not changed. And today also, with respect to, let us say, at least for Section 8(9) IBC, operational creditors, we are discussing about the moonshine dispute. The dispute being a moonshine. The dispute is not a very substantial. It is being raised after the notice is issued. There is no pre-existing dispute. These are all not something which concepts which have not come to IBC and later on. They have been there for years, and in winding up jurisdiction, these questions have already been answered. At the same time, there was the problem of stagnation, civil courts taking years together, and thereafter the DRT came into force in 1993. And in a Section 9 application OA, before the debt recovery tribunals, applications can be made by the financial creditors before a specially constituted tribunal for debt recovery amount due to banks and financial institutions. Today it may be called the Recovery of Debts and Bankruptcy Act. Previously it was the Recovery of Debts due to Banks and Financial Institutions Act 1990. A long title was given. In DRTs, the recovery certificate will be issued, and thereafter the recovery officer, using the 2nd schedule, 3rd schedule Income Tax Act, proceed to cause the sale of the property and proceed to recover the amounts due as per the recovery certificate. And typically, invariably, in all these 19 OA, before the DRTs, the D1 will be the principal borrower, and D2, D3, D4, like that we will set out the guarantors. maybe corporate guarantor, personal guarantor and whatnot. And everything was before the DRT. The PO will hear the matter after completion of pleadings. And there is also the possibility of the borrowers filing a counterclaim before the DRT. So therefore, the whole of the matter, the purpose of telling this is, whole of the matter is before the DRT. Against all those who are liable, and we now discuss about coextensive liability of the borrower and the guarantor. That coextensive liability is what we are now seeing, have been seeing ever since the establishment of DRTs with D1, D2, D3, D4. Everybody is together, everybody is before the single forum, whole of the amount is single amount only, there is no duplication of claim before the principal borrower and corporate guarantor or other guarantors, separate claims and all not there, single forum. The concept was the whole of the amount is under recovery through the DRT proceeding, and all the people who are liable are set out there. And in that single proceeding, you are also able to obtain orders from the DRT against alienation of properties, if any, attachment of properties. Anything can be obtained under the DRT itself in single. So which means the financial creditor that we talk in the legal terms of IBC had the beautiful weapon of DRTs against all the people who are liable in relation to a particular borrowing. And that way it was useful. Now, across the state, across the country, DRTs were established. Unfortunately, though the civil courts cannot be beaten in terms of those days, I'm saying, I'm not talking about the current Commercial Courts Act of 2015. Under the earlier era, definitely years have been going on, and we also saw the Sikh Industrial Company Special Provisions Act. Even the Sikh Industrial Company Special Provisions Act did not deliver goods. There are cases where I personally know I have been climbing 22, 23 floors in BAFR in Delhi. For 22 years also it was going on. 22 floors, 22 years. Therefore, those things were not actually dynamically and dramatically changed even with the advance of the DRTs. But we have to today learn that those days we had, let us say, two important provisions. One was the DRT, which brought a consolidated array of all the people who are liable, and a recovery certificate was issued. The other was the winding up. When it is unable to pay debts, you go for the winding up, where there is no dispute with respect to the amount in demand. We had the two set of things, provided corporate. Non-corporate only DRT was there. Thereafter, you can go for 44 or 45 under the Partnership Act if it is a partnership or dissolution. Therefore, such system was found to be useful for recovery of debt against the principal borrower as well as guarantors. Subsequently, by seeing over a decade, 93 to 2002, that it is not a sufficient weapon in the hands of the financial institutions, and debtors' paradise continued despite the advent of DRTs. Therefore, the SARFAESI Act was introduced, overriding the provisions of the Transfer of Property Act. And whenever we talk about SARFAESI Act, we will only discuss about 13 and 14. Okay, 14 is an ancillary provision. 17 we will discuss. Now, SARFAESI Act is a limited jurisdiction, limited power act. In order to have SARFAESI Act invoked, the borrower's asset classification should have been non-performing asset, and invoking 13.2 to 13.4 read with 2002 enforcement of security interest rules can be possible only if, one and only if, the property is a secured asset. The amount claimed is a secured debt. Therefore, what was happening before the Madhya Chemicals, Supreme Court, 2004, 13.2 was issued. Borrowers and guarantors who are suffering because of their secured asset being taken in possession could always object to that for various reasons. However, there was no requirement of a proper reply, and therefore Madhya Chemicals brought in the amendment so that it was made mandatory to give the response to the objections of the borrowers and guarantors, and thereafter go to the 13.4 stage, and 13.4 is a very elaborate provision, go for auction, reserve price, sale property and recover the money. And in section 17, invariably under 13.2.4, whenever the possession notice and this thing action is taken for recovery, whereas by sale notice is given, 6 or 8 rule, the enforcement of security interest rules, there will be a section 17. An essay will be filed. And SARFAESI Act also did not deliver goods, though it was better, though it was deterrent, though it was really frightening that you are going to see your property in auction. The problem of syndicate, buyers forming a cartel, not bidding in the first auction, then waiting for the reserve price to be brought down, and all these things are drama which we have been seeing from the 2002 under the SARFAESI Act. And there are cases of 2000, I can say some 7 or 8 to my knowledge, continuing to be, rusting, gathering dust without any result, even though SARFAESI Act is in place. Now, therefore, the era of civil courts, the era of DRT, the era of SARFAESI, all these era, we found defaulters paradise, debtors paradise, marginally one notch down, or one notch improvement happening. When it is SARFAESI Act, one thing was clear: the property which is the subject matter of the guarantor should have been offered as security. Normally we call it as collateral security. And therefore, to the extent of that property, SARFAESI was able to be invoked by the financial institutions and take action. So we have seen the scenario change in this way in the landscape. And today also, it is not that because of IBC, because of 15/11/2019 notification, because personal guarantors, corporate guarantors can also be brought under the umbrella of IBC, there is any disregarding or irrelevance of the recovery proceedings before the DRT or the SARFAESI measures. That is the premise with which I wanted to say. SARFAESI is even now relevant, DRT is even now relevant, and IBC has added a powerful weapon in the hands of the creditors generally, not to speak about the banks and financial institutions generally called financial creditors, who are concerned with, who are benefited by, who can invoke the provisions of and take advantage of DRT and SARFAESI. IBC, therefore, brought a scenario change by bringing all the creditors, whether operational or financial, to be able to invoke the provisions of the code, like the erstwhile winding up provisions, where insolvency resolution was not the subject matter, putting the company to winding up is the subject matter. That was the only difference. Irrespective of who owes the debt, who owns the debt. Who owes the debt? The company. Who owns the debt? Creditor. Whether operational or financial or any other creditor, subject to your imagination. Therefore, IBC came as a beautiful, newly devised weapon Prior to IBC also, there was the Companies Act 2013, certain provisions were introduced which contemplated a different regime altogether through the NCLT. Between 2013 to 2016, those provisions were remaining in the statute book without being notified. Thereafter, the 12 December 2016, we saw the advent of the NCLTs having jurisdiction as adjudicating authorities for the purpose of the insolvency resolution of insolvent companies, with a deemed provision that 1 lakh will be the threshold for such insolvency resolution. Of course, we are now fully, I can say, geared up. Personal guarantors, corporate guarantors, everybody, you have the option of DRT, or the option of SARFAESI, the option of IBC, where the properties are already secure. It is mortgaged to the banks or financial institutions. Then, moving the provisions of 95 of the code to bring an application against a personal guarantor whose property is already offered as security will have a difficulty, because you are all aware that compared to the interim moratorium under 96, wherein the interim moratorium will only say legal action and proceeding pending in respect of any debt shall be deemed to have been stayed. The creditors of the debtor, that is personal guarantor, shall not initiate legal action or proceedings in respect of any debt. So if you see the interim moratorium, it prevents the creditors of the personal guarantor from initiating legal action or proceedings in respect of the debt. Interim moratorium takes place automatically when 96 comes into force. An application is filed and interim moratorium shall commence. That means you go and file an application, 96 automatically comes, and creditors are prevented from filing proceedings in respect of any debt. The creditor during the interim moratorium period shall not initiate a legal action or proceeding in respect of any debt. Read with, thereafter, let us say, we will come back to the procedures and all if necessary later on. Thereafter, the IRP is appointed. Some discussion takes place between the personal guarantor and the interim resolution professional. Some discussion and verification, etc., is taking place. The resolution professional is examining the application. The resolution professional will ascertain whether it is in order under 94 or 95. Thereafter, he files a report under 99. Then admission or rejection takes place on 100. Let us go to that stage straight away from 94, 95 to 100. We will fall into 101. 101 is a moratorium. When an application is admitted, a moratorium period starts, and any pending legal proceeding in respect of any debt shall be deemed to have been stayed. Creditors shall not initiate any legal action, as was seen in the IR interim moratorium also. Debtors shall not transfer, alienate. Therefore, two important things we have to remember. Between 94-95 interim moratorium stage in 96 to 101, there is a substantial difference. One is existing proceedings also will be stalled. Another is the debtor shall not alienate, transfer, encumber, dispose of any of his assets. This is a very important provision. You have to remember it very carefully. In section 101 within brackets 2. Keep that in mind, please. Now,
Ravin sir,
sir.
so hello sir. Ravindra Chaturvedi here. Hello. Can you hear me, sir?
Yeah, please, please.
Yeah. So I'm just video.
Huh.
Here, my only worry in this case is, in the case of personal guarantee, as you rightly said that section 95, 94, 95, once the personal insolvency is initiated and NCLT passed the order to file the report under section 99, right?
Correct.
Then after pursuing that report, order under section 100 is being passed. Okay. Because of the Supreme Court stay, many courts are not even entertaining or pursuing any order.
Okay.
Right?
Correct.
The benefit for the personal guarantor as of now, once it is initiated under section 94, 95, no one can initiate any legal proceeding for the recovery against that person. Am I correct?
You are correct. Correct.
So that is in the interest and that is in the favor of personal guarantor, that they are enjoying that immunity and they can take advantage of it. That don't you feel the law should be that once the order under section 100 is being passed, then only they should get the immunity against any legal matter, stay or moratorium start. So I don't know how far the interpretation of law is correct in this case.
I will come back to you on that. I have not gone to that aspect here. I am trying to bring a perspective on a certain point. The point that you are raising, I will address separately after taking the audience through a slew of judgments and NCLAT and NCLT also some cases are there, plus Supreme Court. And then I'll come back to the latest position in relation to section 95, particularly because of this Anil Ambani Supreme Court matter.
Yes, correct.
Then I'll come back to you on the question that interim moratorium stage itself, whether there should be a ban or prohibition on the commencement of legal proceedings in 96 as it is given.
Yes,
the 96 is a qualified interim moratorium in relation to any debt. So the 96 must be read in conjunction with the debt we are talking about in respect of any debt. I will come back to you. In the meantime, I wanted to say was 4A, section 4A of section 19 of the DRT Act, that is Recovery of Debts and Bankruptcy Act, notwithstanding anything contained in 65A of the Transfer of Property Act 1882, the defendant on service of summons shall not transfer by way of sale, lease or otherwise, except in the ordinary course of business, any of the assets over which security interest is created. I am talking about the Recovery of Debts and Bankruptcy Act itself provides a sort of a moratorium qualified by the words except in the ordinary course of business. Further qualified by the words any of the assets over which the security interest is created, and further added by saying any other properties and assets specified or disclosed under 3A. That is, in the application, you have to state the particulars of the properties and all. Therefore, we have to remember 4A is an important provision, and 4A, upon receipt of the summons, bans alienation of properties by whatever means in respect of secured assets, and in addition to secured assets, all other assets which are specified in the application under 3A of the 19. So therefore, I am trying to bring you a picture of how the hands of the borrower or guarantor is going to be tied from alienating or disposing or transferring the properties in 3 verticals I am discussing. One is the interim moratorium 96 and the final moratorium 101 under the code. And the second is the 1904A DRT Act. And I will take you to section 13 also. No borrower, after receipt of the notice under 13(2), 13(2) of the SARFAESI Act contemplates the demand notice for 60 days, and that 13(2) notice itself, go to 13(13), section 13, subsection 13, no borrower shall, after receipt of the notice under 13(2), therefore, it is incumbent upon the authorized officer of the banks and financial institutions to ensure that the receipt is acknowledged or at least recorded, service is provable. After receipt of the notice under 13(2), that is demand notice, shall not transfer, sale, lease otherwise than in the ordinary course of business any of the secured assets without prior consent of the secured creditor. Therefore, now we have three provisions in front of us. Looking at financial creditors angle, the code will apply to any creditor, but from a financial creditor angle, we bring the DRT, we bring the SARFAESI, and you will find 19(4)(a), you will find 13(13), you will find 96 and 101. This is the landscape. So the moratorium that is granted under section 101, that the debtor shall not transfer, alienate, encumber, dispose of any of his assets and his legal rights and beneficial interest therein, is something not new. It can set in even before that he would have been a person affected by it because of an action under section 19 of the DRT Act, RDB Act, or an issue of 13(2) notice pursuant to operation of 13(13). This is what we have to remember when we talk about recovery of money due from creditors and the debtors and personal guarantors generally. Now, therefore, from a bank's financial institution's perspective, initiating a 95 immediately running to the code is not advisable, provided there is a secured asset or there is a measure which is better than available through the DRT. You will be able to achieve the purpose of the attachment of property, the non-alienation of properties, if you are able to use 19(3)(a) read with 19(4)(a). That will be the best course of action from a financial creditor's angle, wherever that person has the right to invoke the RDB Act. Therefore, moratorium that we are discussing in 96 or 101 is only a step further in order to achieve the purpose of the debtor personal guarantor not alienating if he has already been subjected to 19(4)(a) or 13(13), which operates for secured assets under the SARFAESI Act, which operates for other assets also provided they are specified in the statement, here which operates generally for all the assets. Not only all the assets, 101 further says his legal rights. 101 further says his beneficial interest therein. Therefore, 101 is a sweeping clause. 13(13) is a restricted clause to secured assets. 19(4)(a) is a clause which liberally construes all assets which are not specifically mortgaged hypothecated in favor of the bank can also be added in this statement under the RDB Act, under section 19, provided the bank or financial institution had specified it under 3(a) in the application particulars of the various properties. Therefore, this recovery of debt from personal guarantors is not a subject which must be looked at from chapter 3 or 4 alone of the code. It requires a holistic view of the whole of the Act, and in addition, we have the fundamentals of the contract of guarantee, which probably everybody would have gone through, but just for the sake of persons who are in the audience, a mixed audience will be there. There are at least 5 important things we should know in the guarantee. Number one, 126 of the Act defines guarantee, that is guarantor, surety, principal debtor, and principal creditor. Therefore, that is a fundamental definition. Where do you get the words surety, guarantor, and whatnot? That is the 126, which clearly defines those terms, which are very essential. Number two, The consideration for guarantee is set out in 127. No guarantor can say, I have not benefited personally, though borrower would have received the money. I only guarantee. 127 is an important one because it is a consideration which gives the benefit to accruing to the principal debtor is deemed to be sufficient consideration. In 1872, they have written this beautifully. Then comes the 128, which is frequently discussed. Liability of the guarantors are coextensive with that of the principal debtor unless otherwise provided in the contract of guarantee. Today, a person wants to sign the contract of guarantee. He has the right to bargain before the banks and financial institution that only after remaining amount unrealized from recovery from the principal debtor, I will come, I will offer. Only I will offer this much, not more than that. I will offer only my net worth of today, not the incremental net worth. But bargain must be made at that time. Today, people in the large corporates are not offering personal guarantee of the directors or promoters at all. Today, banks and financial institutions are agreeing to that situation and not even accepting, not even insisting on guarantees, except in MSME, these large corporates are able to escape. In MSME, there is no way because there will be a lot of messing up and mingling of funds. 128, therefore, is relevant today also, and it says personal guarantor or guarantor for that matter, corporate guarantor, any guarantor, the liability of the guarantor is coextensive. 128 is an important provision. Then comes revocation. Whenever we talk about revocation of guarantee, you remember there are cases where we have discussed and we are going to discuss that the principal debtor has not acknowledged, the liability has become time barred. Liability is coextensive. The same principle you can apply. Principal debtor has acknowledged, limitation has survived, fresh period has commenced, coexistence liability is on the guarantor also. Guarantor will not be specifically, separately asked to sign. Therefore, importance of 130 and 131 are very important in order to say revocation of guarantee. 130 is clearly saying the continuing guarantee is capable of being revoked. A person who is a guarantor today, let us say a person who is a disputing director, there is an oppression mismanagement case, for example, which Philip Matthews sir would have seen several times. That person can always write to the bank saying, no, I'm not going to continue my guarantee. He can invoke 130. Similarly, variation of terms of contract, discharge of surety. Suppose the bank or the financial institution, the guaranteed automatically discharges. You are all aware the resolution plan discharges the corporate debtor's original liability. Does not mean it discharges the guarantee's liability also for the remaining amount, which I will take you through separately. Therefore, 131, 132 and all is important. And guarantor steps into the shoes of the creditor is also important. There are cases where the guarantors have pumped in the requisite money, settled the financial creditors. Therefore, we can invoke section 140, 141. The right of the surety will accrue to, the right of the creditor will accrue to the benefit of the surety for the creditor securities. So there are cases where in 2005, if my memory is correct, I have constructed a scheme of arrangement where the secured creditor is paid by the guarantor. In the financial statement, I classified the guarantor as a secured creditor, applied for a scheme of arrangement to issue shares in lieu of the amount brought in, and knocked away the secured creditor and made it a capital, removing the existing capital through a scheme in a listed company. And therefore, these provisions fundamentally are useful not only for this, but also for reconstruction or reorganization or a corporate debt restructuring and all. Fundamentals of all these things now we have seen. Now I will take you through the certain decisions which are important in this field. If I remember, the one which we remember is some old decision in screen share. I'll be able to share it, I guess. 1 second. Let me take you to this particular decision. In screen share. Number 1. This decision is State Bank of India versus Ramakrishna. If you see this decision, it is dated, I'll go to the end and show you the 2018 date. 14th August 2018. At that time, in 2018, 14th August, notification 15 November 2019 was not there. The glossy class E under subsection 2 was not added. That is, personal guarantors as a definition, personal guarantors to corporate debtor was not added. That is class E. I call it as glossy, because the guarantors are rich with money, though the corporate may not be having money. And in Ramakrishna, this SBI versus Ramakrishna, the Supreme Court of India, prior to notification, had opined like this. I will take you to para number 19 straight away without going into the elaborate things and all. Please see here. Section 60 of the code refers to insolvency resolution and liquidation, both for debtors and guarantors. The adjudicating authority is NCLT, having jurisdiction over the registered office. So this subsection is important. It locates the tribunal. So what is the true import of subsection 1 of section 60? Section 60, subsection 1 is not saying anything except saying the relevant tribunal is the tribunal where the registered office is situated. That's all. Territorial jurisdiction ke liye this particular provision has been added. So far as personal guarantors are concerned, we have seen that part 3 has not been brought into force, which I told you already. Therefore, so far as individual personal guarantors are concerned, they will continue to be proceeded against the 1908 and 1920 insolvency law at that time, because 243 was not there, repeal was not made, provisions have not been introduced. That was the situation. It is for this reason they are talking about the relevance of subsection 2 of the IBC section 60. Section 60 speaks about an application relating to bankruptcy of a personal guarantor, of a corporate debtor. Bankruptcy proceedings in relation to a personal guarantor to CD, that is PG to CD, shall be filed before NCLT, and that was the section 62 operation, whereas 60 within brackets 3 said it talks about an existing proceeding already initiated elsewhere shall stand transferred to the adjudicating authority with the insolvency resolution process going on in the corporate debtor. So this is a very important matter, which shall stand transferred to the adjudicating authority dealing with the insolvency resolution process or liquidation of the corporate debtor. An adjudicating authority defined under 5.1 is nothing but the NCLT. Therefore, para 21 is important. Ramakrishna, SBI versus Ramakrishna, 2018, August 14, Supreme Court says, Section 60 within brackets 2, Section 60 within brackets 3, the moment there is a proceeding against the CD, pending under the 2013-16 code, bankruptcy proceeding against the individual personal guarantor, if already initiated before some other, this thing will be transferred. If initiated after that, it will be commenced before NCLT. Therefore, it is incumbent upon the applicant to show there is a action under the 2016 Act against the corporate debtor. Para 21 said CARP or liquidation must be there in order to invoke the provisions of subsection 2 or subsection 3 of the IBC. This is the reason why we are reading Ramakrishna. Now all of us are aware about the 2013 Act ke baad, 15th November 2019, by notification 4126, the NCA issued notification conferring the commencement of the operation of these provisions 94 and all. So after 15th November 2019, the scenario changed totally. But prior to going to the 15th November 2019 scenario, we may be in a position to see, just for some purposes, one or two decisions. One is the Vishnu Kumar Agarwal Piramal. Vishnu Kumar Agarwal Piramal. Anyway, Athena is sufficient to say. Athena is a subsequent decision of 2021. In this case, it is, you can see here, para number 10, I will read it. You can see here the reference in para number 3 to Vishnu Kumar Agarwal versus Piramal Enterprises, wherein it was held that once a Section 7 petition is filed against the principal debtor has been initiated, the financial creditor cannot file, very important proposition at the time, cannot file another application for the very same set of claim. This is very, etched in the memory, that how our people, I mean our people in the sense everybody, including the judicial, quasi-judicial forums, have seen the situation of the same law from different perspectives and lenses and eyes. You will see in Vishnu Kumar Agarwal Piramal, the NCLT said, having already filed your claim for the full amount before the principal debtor, you cannot file once again against the corporate guarantor to bring another CARP to the corporate guarantor, because you have already claimed, your full claim is before the CD, who is the principal borrower. Therefore, that was the decision on 8 January 2019 in Vishnu Kumar Agarwal Piramal Enterprises. Financial creditor cannot file another application on the very same set of claim. Subsequently, let me take you to the decision in Piramal. It is given here, it is reiterated here, and I don't want to read it again and again. But come to section para number 10, which takes care of the position of State Bank of India versus Ramakrishnan, and against this, the proceedings, it is clearly written, basics, the fundamentals of 128. Under 128, the surety's liability is coextensive. It is claimed that this principle is not applicable to insolvency proceedings. That was claimed. It was argued that for the same amount, there cannot be two proceedings, one against the borrower and another against the surety. Relied on Piramal, this was done. So ultimately, it was decided in Athena that there is no such bar. There is no such bar. This is the important proposition which is found in Piramal. Section 7, applications can be filed against the guarantor 1 and guarantor 2, and both are allowed. So we must remember that the issue has been resolved in one aspect, that the claim can be made, but if there is a recovery, the subsequent claim can be reduced. In fact, I am arguing a matter before Bangalore bench very recently, in which the very same Piramal is there as financial creditor. Whole of the money is brought in by the guarantor, and the entire 55 crore is settled, and therefore the claim of the financial creditors has been removed so far as Piramal is concerned. Resultantly, entire Piramal as the financial creditor has gone. The remaining people alone are constituting financial creditors now. Because once the guarantor steps in, whether through this proceeding or whether through any other proceeding, and makes claim, or a financial creditor makes claim in two different cases, that doesn't mean the recovery will be stopped or there will be a difficulty. No hindrance, no obstacle. Claims can be made. Ultimately, whichever claim succeeds and fructifies into realization of proceeds, the other claims have to automatically fall. There must be reduction. So therefore, we must go from Ramakrishnan to Vishnu Kumar Agarwal Piramal to Athena. So we have traveled from 2018 to 2019, prior to notification to subsequent notification, which I will come back to you to Lalit Kumar Jain now. Here you see Lalit Kumar Jain is a decision. How it came is, there was a application by IBBA before the Supreme Court. And IBBA said that all the matters must be brought before the Supreme Court because several proceedings have been initiated against several high courts. Therefore, conflicting decisions of several high courts is possible. You can see the head note itself here. Transfer of petitions because conflicting decisions can be avoided. This is how the Lalit Kumar Jain came to be decided. Now, in this decision, Supreme Court has clarified. Once again, I will take the Lalit Kumar Jain, because this screen share, somewhere it is affecting my visibility. Yeah. So you can see here, Lalit Kumar Jain versus Union of India decided on 21 May 2021. Athena Energy NCLT is July 2021. Now, therefore, this decision of the Supreme Court in 2021 is subsequent to the notification. Pursuant to IBBA making an application to Supreme Court to pull all the petitions across the country and make a decision so that a conflict of decisions can be avoided. It's a very important decision. And let us straight away go to para 45 for the purpose of the perspective. Para 45 of this Lalit Kumar Jain is a perspective paragraph. which says the Solicitor General submitted that Part 2 of the code applied to all categories of corporate entities who are debtors by virtue of 3 within brackets 8. Corporate debtor is who owes a debt is a corporate debtor. Likewise, corporate guarantor is also defined. It is also a corporate debtor. By the impugned notification, which is the 15th November 2019 notification, Part 2 were confined to corporate debtors and only other classes corporate guarantors. Now comes the personal guarantors. Yet personal guarantors being individuals were not included in the Part 3, the functional and operational purposes. Solicitor General submitted. Part 2 outlines the mechanism, and this takes a sweep resolution for the whole thing. Therefore, come to the last sentence here. I am highlighting. As a result, a conscious decision was taken to enforce Part 3, operationalize the mechanism suitably for a class of individuals called PG to CD. So therefore, a classification was brought as a PG to CD under 2 class E of the IBC. Therefore, 94 to chapter 3 is running up to 120 and chapter 4 is running up to 121 to 178. These are all applicable to the persons who are called the PG to CD under class 2E. This is the perspective of the Lalit Kumar Jain, and here we need to go to very importantly 1 or 2 paragraphs alone. I will take you to 70. The principal ground of attack in all these proceedings has been executive government could not have selectively brought into force the code only against individuals who are personal guarantors, leaving all other millions of individuals happily. Only some people have been made sad. This is the paragraph 17, the underlying purpose of your Lalit Kumar Jain petition. Only personal guarantors are sad, all others are left happy. They cannot celebrate Happy New Year. That's what they are saying at that time. Now, what is the decision? Let me go to the decision part of it, and that is in 119. This is a very important decision. Some of you who are interested, you can read para 97. This gives you the sequence of all these IBC one after another up to the date. Lalit Kumar Jain is a May 2021, not far away, just about a year before. It gives you the entire notifications, numbers, provisions, date of coming into force and all. It will be useful for you, this chart in para number 97, but I am going straight away to 190. So here you have to read sum and substance only. I am going to tell, I am not going to tell everything. 119 to 123, probably you may have to read with the time. At the time in 2021, they said it is possible. I have seen this decision and I still continue to say that when the corporate debtor is under CARP or liquidation, these proceedings can be initiated. That is what is the law the court has said. This court was clearly cognizant of the fact, after setting out what the Ramakrishna said, this court says, insofar as it inserted 2E and altered 60 within brackets 2, it was aimed at strengthening the CARP process. Please read this language, very important. It was aimed at strengthening the CARP process. Matlab, CARP must be there and you can strengthen it by this thing. Remember the DRT aspect which I was telling you, a single forum against all the people in relation to a debt. That was actually the visualization which we need to remember here in 121. At the same time, since the code was not made applicable to individuals, the court had no occasion to consider what would be the effect of exercising of powers with respect to the notification dated 15/11/2019. The argument that insolvency process, application of moratorium, etc. are incongruous is all dealt with in this. Finally, they say, it is clear from the above analysis of the parliamentary intent was to treat the personal guarantors differently from other categories of individuals. There is an intimate connection between such individuals, such is important here, and the corporate entities to whom they stood guarantee. Therefore, the process of insolvency in part 3 is to be applied to individuals, whereas corporate debtors is to be applied under part 2. These are all clarified here, and therefore the court says there is no instance of legislative exercise which should be struck off. So therefore, 125 para, it says once a resolution plan is accepted, the corporate debtor is discharged of liability. As a consequence, the guarantor will also be discharged. That was negative. This was another argument. Please remember this. Here you have seen 127, entire contract act is set out. 128, the question which the petitioners urge that in view of the finality of the resolution plan, liabilities will get extinguished, and they rely on 128, 133. This was the second premise, second question, very important question raised before the Supreme Court in Lalit Kumar Jain. In Lalit Kumar Jain, this was the second question. And 133, the Supreme Court says, sanction of a resolution plan, finality of a resolution plan under 31 does not per se operate as a discharge. As to the nature and extent of liability, much would depend on the terms of guarantee itself. Therefore, we go back to 131 and all discharge of surety. We need to go to the fundamental provisions of the Contract Act, and the discharge of surety can happen only in accordance with that, nothing else. However, this is a very important proposition under 133, and we need to remember this 133 and understand the finally the provision is in 136, the proposition that approval of resolution plan does not ipso facto discharge the personal guarantor. This is what is the final verdict of the Supreme Court in 2021 in Lalit Kumar Jain. Now I'll come to some practical case which I have handled. Air travel enterprises. You can see the screen now. Some 67 crore is due. NCLT imposed the SARFAESI. I moved the NCLT. And in para number 20, in this appeal, in NCLT, you can see here, the corporate debtor has proceeded to settle. There is a negative impact, COVID and whatnot, resort business, etc. Therefore, ultimately, the court says like this. Keeping in view of the peculiar facts of the case, NCLT I argued in Delhi, we dispose of this appeal with a direction that if the corporate debtor fails to settle in 6 months, the respondent is at liberty to take steps, and therefore the order is set aside. You can see here the admission of Section 7 application is set aside. Therefore, in air travel enterprises case, due to peculiar circumstances, 9/9/2021, NCLT set aside the Section 7. The reason is there was peculiar circumstances. Corporate debtor was operating a resort. Now, why did I say this in connection with today's subject? I will come back to. Once this 9/9/2021 order came, CARP is gone. CARP is revoked. Now there is no CARP. Subsequent to this order, the financial creditor who originally initiated Section 7 did not bring because there is a 6 months window. Some other financial creditor brought 95. Some other financial creditor brought 95. Now, NCLT orders proceedings under 95. Despite the fact CARP was not invoked. It's a very peculiar case and very important proposition. Therefore, when you see here, 27th January 2022, in the same matter, 27/1/2022, you can see here, the impugned order is to be stayed because the argument was there is no CARP personal guarantor proceedings under 95 cannot be invoked, relying on Ramakrishna as well as Lalit Kumar Jain. So NCLT on 27 January 2022 stayed the proceedings against the personal guarantors. Now you know that day, this 27/1/2022, you may be aware, on the same day, before the same NCLT, but in Delhi, this is Chennai bench, my case. There was another case in Delhi bench, that is principal bench, where the NCLT on the same day in a similar matter said proceedings can continue. No stay. Against that, we have this particular judgment which everybody refers, Mahendra Kumar Jajodia, State Bank of India, same State Bank of India, Supreme Court, 6th May 2022. Very important decision. But you see the order, how it is written. Supreme Court appeals are dismissed. Now you see the order. We heard the learned solicitors general and the learned senior counsel of the parties. We do not see any cogent reason to entertain the appeal. Mahendra Kumar Jajodia is the matter I am referring to. 27 January 2022, NCLT principal bench allows the proceeding against the guarantors. So the guarantor is left with no option. He rushes to Delhi Supreme Court. Supreme Court stays it initially, but subsequently by 6th May 2022, floodgates have been opened with Supreme Court saying no problem whether CARP is there or not. Proceedings under 95 can be commenced by the financial creditor, and they say do not see any cogent reason to entertain the appeals relying on the NCLT decision of 27 January. Therefore, with the 6th May 2022, whether CARP or liquidation is there or not, proceedings against the guarantors is possible, and therefore we have to remember today what is happening is in some benches proceedings are ordered, in some benches that no proceeding is there, it is all adjourned because subsequent to Mahendra Kumar Jadeja, Anil Ambani case and all came, and Supreme Court seized of the matter. To the extent I have understood today, 13th it came and posted to 17th January. And this is the scenario and landscape with respect to this. Now, having done this analysis, last 2 minutes only we will take. What is the great deal about it? Just read 3 provisions. Number 1. See, 138, even after declaration as a bankrupt, on the expiry of 1 year from the bankruptcy commencement date, the bankruptcy is discharged. 138, such a simple provision. There's nothing great about it. Maybe you have the tag of bankrupt for a period. You have declared, you have raised your hands. You are not a willful defaulter. You are not run away from the country and going in metro of some other country. 138 simply discharges you within 1 year. Therefore, if a person is really hard pressed, he has difficulty, he can invoke 94 apne aap. Discharge proceedings are after all, after 1 year, you are going to be a free man. You will be able to do everything that you can do as an ordinary person without any problem. So 138 is a beautiful weapon, beautiful provision. The debtors, guarantors can use it and save themselves from having any other problem by using this. Now come to 120, 139, effect of discharge, and 140 disqualification, and 141 restrictions. I do not find any great difficulty for a person who wants to live ordinarily doing his job or business. 140 and 141, and they are all operating up to what time? They are all operating only up to 138. 141 disqualification, 140 disqualification, 141 restriction. These operate only up to 138. and 138 operates for only 1 year. Therefore, I wind up by saying, in select cases, let the banks not rush under 95. If there are properties and secured assets, SARFAESI is the better one. Let not moratorium start. In so far as debtor is concerned, 94 can also be invoked. They can raise their hands. Even if they are declared bankrupt, if a repayment plan doesn't work, nothing is going to happen. After all, after 1 year, they will be honorable living citizens without any problem. Thank you very much. I will answer only one question which was originally raised. That was in 96 interim moratorium. Why should there be a blocking of legal proceedings? Why not leave the 101 alone? That was the question. That is, I think I will escape by saying, it is some subject matter of a parliament to discuss. Maybe these suggestions can go. The point is noted, creditors of the debtor shall not initiate legal action or any proceedings in respect of any debt is a moratorium which operates in some cases in favor of the debtor. Therefore, Mr. Ravindra Chaturvedi was asking, why should this be now? Why not at 101 only? This is a difficult question. The efficiency of the entire travel. Please see the travel from 94, 95 to 100, just 4 sections. Very quickly the travel will be over and 100 order and 101 moratorium will come. So this is a very short period. Therefore, there is no big difficulty is going to be caused. That's all, sir. Thank you very much.
So thank you very much for a wonderful presentation, sir. So, Secretary of this association, sir, I would like to, my duty is to pay a vote of thanks to the wonderful presentation you had made for us, sir. And so let me get to my duty. Sir, the session delivered by you was extensively educative and enlightening, and you had actually given us in a very short span of time, sir, you had given very lucid and clear presentation about the provisions of the IBC as well as the SARFAESI from a very legal perspective, and had done very justice to the topic of the today's seminar, sir. Now, sir, in your presentation, you had explained in a very simple manner the provisions of the SARFAESI and DRT, and its relevance, even with the advent of the IBC provisions, sir, with respect to the personal guarantors. So you had took us through the provisions of the Contract Act to explain the basics of the guarantee and related terms. The case laws, especially the Lalit Kumar Jain's judgments and the other judgments in which you had appeared before the NCLT and NCLAT, and those information, sir, was very educative and useful for all the professionals who are attending over here. Today, sir, this is the first, as our president had mentioned in the presentation in the beginning, sir, in the welcome speech. This is the first program which we are organizing after the inaugural session, which was held around 6 months back. So, sir, we are planning to have this kind of programs in a regular manner, and this presentation which you had made is actually giving us a very good confidence to go ahead with that kind of presentation. So today we had around 61 registrations, and 45 people had attended the programs throughout the session. And sir, we are very much grateful to you over here. And though you are a member of the association, sir, it was very helpful for all of us to share the knowledge and to hear the knowledge from you, sir. Sir, we, on behalf of the members who are attending over here and the members of the executive committee of this NCLT Kochi Bar Association, thanking you from the bottom of our heart for your enlightening speech and your valuable time which you had spent with us, sir. So I also thank on behalf of the NCLT Kochi Bar Association for all the members who are attending this session, as well as the non-members who are joining us in this session. Even though they are not a member of this association, they had taken pain to attend this function because of the relevancy of the topic. And I, on behalf of the association, thank each and every one of you for spending your valuable time and being with us for this evening. And thank you very much. Thank you, sir. We will be winding up the session after this. Thank you, sir.
Thank you.
Thank you.
Thank you.